Hello, everyone. Now that you have negotiated everything you want in your contract, you relocate yourself with your family. You even start to work and then realize that the things promised orally are nowhere to be found in the contract. How could you have avoided this? My name is Premkiranreddy, founding attorney of Reddy's law firm. In this episode, I will lean on my training and experience in both the medical and legal fields to answer these questions. First, while you negotiate, jot down things you reached an agreement on. Sometimes, instead of a contract, they will first give you a letter of intent, an LOI. So you feel good that you got this LOI and shift your whole family to the new area where you will start employment. Your spouse gets a job, your children are settled in school, and you rent an apartment or maybe even put a down payment on a house. You leave your previous job because you are promised several lucrative things, and you even got an LOI in written. But then when you reach there and are given the contract in hand, or worse, you sign it assuming everything is in it, and realize later that what was promised is nowhere to be found in the contract. You realize that you are now worse off than at your last employment, and you cannot move again as you are stuck in a contract that you signed. The rest of the employment is not going to be pleasant now. This is because the LOI is not the actual contract with all the terms in it. And further, it does not have to be binding. A workaround would be to explicitly state in the LOI that the LOI is to be binding on all parties. But this is not the strongest route. The stronger route is getting the actual contract in hand before you leave the previous employment and shift your family. Next, when they send you the final contract, think like a lawyer. Go over every line and make sure everything you talked about is actually written in the contract. If you need to have an attorney look at it to make sure you haven't missed anything, do so. You may find ways to enforce what is orally said and not in the contract, but that could be hard. When it is all explicitly written in the contract, all you have to do is point to the contract. You can sign the contract remotely by various e-signature services like DocuSign or HelloSign. There may be other contract softwares that your employer uses that have e-signature capabilities in them, or you can sign and scan the document and send it via fax or email back to them. Better to know that what you are getting in written in a signed contract and make sure of it before you uproot your family. It may also be a good idea to ask for the policies and procedures of the hospital, as you will be responsible to adhere to those as well. And you need to know if there is something that sticks out. Remember, if you get the contract and you do not respond, the employer can rescind the offer before you sign it. So make sure you look over the contract in detail, and if necessary, have your legal counsel look over it as well. Sign it and send it back before the offer is rescinded. So to recap, make sure all the agreed negotiations are written in the contract, have the actual contract sent over, and sign it after carefully reading it, and try not to rely on the LOI. Please also be on the lookout for my various other topics, including other contracts, ethics, health law, medical malpractice, and dispute resolution. Thank you for watching. Hope to see you soon in the next episode. Bye-bye.